90. We have reached a plea agreement with the state in exchange for a plea of guilty as charged. On count 1, the state is recommending an adjudication of guilt, a sentence of minimum mandatory life in the Florida Department of Corrections while designated as a prison releasee reoffender. He shall have no contact with Jeff Nunn, Charlotte Arnold, or Jennifer Zamorsky. He would be assessed standard court costs, $100 cost of prosecution, and $150 public defender fee. All of that money would go to collections. On counts 2 and 3, it would be an adjudication of guilt and time served. And for the record, this is a serious case that we have not done any investigation or taken any depositions on, but this is a plea offer that Mr. Nunn has indicated that he really wants to take. So that's where we are.
Judge, I do have some items of evidence to place into the record. I've shown defense counsel, and I could do that at this time. If
You can do it at this time, then I'll inquire of the defense.
Your Honor, I did receive a letter on May 2nd of 2022 from Mr. Nunn. He wrote the letter to me directly, basically asking for life in prison. This was something I discussed with the family. The family did write a statement that they wish for me to read on behalf of the family. But I would like to introduce the letter that Mr. Nunn wrote to me in support of the fact that this plea is going to be entered freely and voluntarily. So this is something that Mr. Nunn wants to do, and the state and the family are in agreement. So at this time, I do have State's Exhibit 2 to enter into the record, which is the letter written by.
Any objection?
No, Your Honor.
Without objection, the court will enter State's Exhibit 2.
I also would like to introduce the defendant's pen pack. This is going to be a stipulated item of evidence entered into State's Exhibit 1. Both defense counsel, the defendant, and myself are in agreement, and we're stipulating that the defendant is a prison releasee reoffender. However, I would like the court to review the pen pack and make an independent finding because, as the court is aware, the PRR enhancement does make the second-degree murder charge mandatory life in prison, day for day, no early release. So at this time, the state would offer an evidence State's Exhibit 1, which is going to show the date that Mr. Nunn was previously released from prison, which was November 1st of 2021. Based on the PRR statute, which is 775.082, sub 9A1B, it states anyone who commits murder. There's an enumerated list there, but murder is one of them. Within 3 years of being released from the Department of Corrections is classified as a prison releasee reoffender. So I do have that item to introduce into evidence now, and I'm going to turn it to the page that shows this.
Very good. Any objection to the Exhibit 1?
No, Your Honor, and I discussed prison releasee reoffender with Mr. Nunn, and we put it in the plea agreement, too.
And the defense is in agreement as to the his status as a prison release reoffender?
Yes, sir.
And for the record, he was released from prison November 1st of 2021, and the murder occurred on January 9th of 2022. So we're well within the 3 years to qualify him.
Based on this filing as well as the agreement of the parties, the court does makes a finding that the defendant is a prison release reoffender.
And the final item of evidence that I would like to introduce is a statement from the family. I can do that after the sentence, or I can do it now, Judge, whichever you prefer.
Doesn't matter.
Doesn't matter.
Do it now.
Okay.
Marnie, you need anything? You need? Okay, go ahead.
Judge, this is a statement submitted and notarized. It's from Miss Jennifer Zamorsky. Miss Zamorsky is the sister of Mr. Nunn, and Mr. Nunn is accused, and he's pleading and admitting that he killed his mother, which is also Miss Zamorsky's mother. And this is an impact statement to the court by Miss Zamorsky, and it's addressed to Mr. Nunn. Not a day goes by that I do not miss my beloved mother. She was the one person I could depend on no matter what. She was my best friend whom I talked to almost every single day. She was a mother who loved God, her children, her grandchildren, and all of her extended family who she kept in touch with frequently. She never stopped praying and never gave up hope on any of her children. The tragic way in which my mom was taken from this earth haunts me and my entire family. I continue to have nightmares and trouble sleeping when I reluctantly remember Sunday night, January 9th, when I discovered my beautiful mother laying on her bedroom floor, lifeless, with dried blood all around her. How could it be that her own son, who she gave life to, did this? I did not understand and never will. As far as I am concerned, there isn't justice here on earth for my mom, Betty Stewart, when it comes to a sentencing. Justice will be handed out in the next life by the Lord our God. No punishment truly fits the crime. Mom was taken in a way that was horrible, evil, and disgusting. My brother, Joshua Kyle Nunn, did this evil thing and does not deserve to keep living. However, my mother would not have wanted death as a sentence imposed on her own son. We remember the 5th and 6th commandments, honor thy mother and thy father, you shall not commit murder. And that is the only reason that my siblings and I have decided not to pursue the death penalty, but instead accept a plea that he serves the remainder of his life in prison without contact to any family, where he cannot manipulate, lie, or kill another victim. And that's submitted respectfully by Jennifer Zamorsky. State's Exhibit 3, may I approach?
Assume without objection.
No objection, Your Honor.
Court will accept State's Exhibit 3.
No other evidence from the state.
Okay. Mr. Nunn, let me swear you in. I need to inquire. Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. So, I see I'm looking at the plea and sentencing agreement that appears to be signed by you. Is this your signature?
Yes, sir.
And have you had a chance to go over this plea and sentencing agreement in detail with your attorney?
Yes, sir.
Now, I know this may sound like a silly question, but I need to ask you, what's your level of schooling?
10th grade.
Can you read and write?
Yes, sir.
Okay, so you understand you've been able to read through this plea and sentencing agreement, you understand it?
Yes, sir.
Okay. And 2 of the 3 counts, the grand theft and the petty theft, are adjudication of guilt, time served. So those basically have already been resolved. Obviously, the second-degree murder charge is what we're dealing with here today. Based upon this, your designation, and by the court's designation of you as a prison release reoffender, the sentence and what is contained in this plea and sentencing agreement is a minimum mandatory life. That means day for day, no credit for time served. That's, do you understand that? Has that
Yes,
been
sir.
explained to you?
Yes, sir, I understand.
Okay. And your attorney made the point, it's an important point, that this plea is being entered by you without the benefit of any substantial discovery by your defense team.
Sir.
Okay. That's a little bit out of the ordinary. Normally, we do the discovery so that your defense say, hey, here's what we see, and give you good advice. So it's limiting what advice he can give you. But you're wanting to enter this plea agreement here today.
Yes, sir.
Why?
I feel like it's in my best interest.
Why?
I like to please my family.
Did you do what was charged?
Did. I was under the influence of drugs. And like, there's no win. Nobody wins. Nobody wins here today. And I didn't deserve that.
So importantly, I want to make sure, I guess you don't have any reservations about accepting this plea agreement. It's being done freely and voluntarily?
I feel like that's what I deserve. I can't make it out there in society. Like, been in and out of prison since I was 19. This would be my 4th time. And even if I got 30 or 40 years, that'd put me in my 70s. I'd be homeless. I'd just rather stay there and just let me die there.
Have you had a chance to go over all of your different options with your attorney? You obviously have
Yes, sir,
a
I
very
have.
seasoned attorney. Have you been able to kind of go over from a legal standpoint your different options that you have? One of which obviously is this plea agreement that you're agreeing to here today, but have you had a chance to go over that with him, the different options that you have, or what you want to do here today?
Yes, sir. This is what I want to do. I want to enter this plea agreement.
And you understand that by entering this plea agreement, you will basically eliminate, except for a few unusual circumstances, the right to appeal this.
Yes, sir.
Okay. And that this is a final resolution of this case, and that you're waiving a number of very important constitutional rights. You've heard the right to a trial, the right to confront witnesses, the right to have the state prove their case beyond every reasonable doubt. All those things, valuable constitutional rights that you have as a U.S. citizen, you're waiving those rights by entering this plea agreement. Is that what you want to do here today?
Yes, sir.
Is the defense objecting to the score sheet?
No, Your Honor.
Okay.
And Your Honor, there is one additional thing for the record.
Please.
It's my understanding that defense counsel did have Mr. Nunn evaluated for competency.
Okay.
And Mr. Russell, if you would like to, inform the court of those results.
We did, Judge. We did not file it with the court, but we were just making sure that he was competent to proceed and competent with his plea, and the report indicates he was competent to proceed.
Okay. So, last time, any questions that you have of your attorney, which I'll allow you to discuss privately with your attorney, to have any questions that you have before I accept the plea and make the sentence?
I don't have any questions.
Okay, Mr. Nunn. Based upon your testimony and the evidence that was presented here today, as well as the comments or arguments by counsel, the court will accept this plea and sentencing agreement as set forth. Counts 2 and 3 will be adjudicated guilty. Defendant will get credit for time served. As to count 1, second-degree murder with a weapon, the court will adjudicate the defendant guilty and sentence the defendant to a minimum mandatory life in the Department of Corrections designated as a prison releasee reoffender. In addition, there shall be no contact with Jeff Nunn, Charlotte Arnold, or Jennifer Zamorsky. In addition, there are several costs, cost of prosecution, public defender fee. Those would all go to collections. Very good. Anything further, defense or state?
No, Your Honor.
Thank you very much. Please keep the prisoner in custody. Hale Orr.